Peter, nice to see you again.
Hey, Trevor.
It's not often that we chat to each other on Old Year's Eve.
Yeah.
Old Year's night. But since tomorrow is the start of a new tax year, I wish you a happy new year.
That's true.
I thought before we start the subject matter of the podcast, I might just mention that the January-February 2003 issue of the Taxpayer, which you can see here, the binders were received today, and they're in the process of being posted. And of course, it's been available electronically for some time, for about a month. And we do send out an email for those who sign up for it, just telling people what's in it. So I just thought I'd mention, for those who haven't seen it, what's in the January-February 2023 issue. And what's quite nice for me about this issue is all of our editors have made a contribution this time. So the editorial deals with the deductibility of interest on borrowed money and the withdrawal of the SARS Practice Note 31, which is something we want to talk about a bit this evening. Then there's an article entitled "Thistle and the Rustle of Jurisprudential Chaos in Our Tax Law" by Dennis Davis, also the Honourable Mr. Justice Davis, because once a judge, always a judge. Isn't that a wonderful title? Thistle and the Rustle of Jurisprudential Chaos.
Yeah,
couldn't agree with him more. Then there's an article, "Associated Enterprise or Dissociated Enterprise" by Ernest Mazansky, and I think that has to do with Section 31 and transfer pricing, if I remember correctly. Then I contributed something on interest and related or similar finance charges. There's an article, part one of an article by Keith Engel of the, let me get this right, South African Institute of Tax Practitioners, is that right? It's very nice to have an article by him, formerly of Treasury. And his topic is "Discounted Cross-Border Loans to Foreign Trusts, Clarifying the Mix of Anti-Avoidance Provisions." And part one deals with the problem, and in the March issue of the Taxpayer, we'll have part two, which is subtitled "The Solution." Then there's an article by none other than yourself, Peter. So Peter Dachs has written "The Tax Implications of Preference Shares." And then finishing up that issue, we've reported a case, which is ITC 1958, 1958, and it's to do with expenditure actually incurred and the timing of the deductibility of variable expenditure. So that's what's in the latest Taxpayer, just to show that we haven't been entirely idle. Right. The idea for this evening is that we'll discuss two topics. The first is the withdrawal of the SARS Practice Note 31. And the second is the much spoken about Coronation case, which was handed down, I think, on the 7th of February. Is that correct? Very recent. So let's say a word or two about the withdrawal of the SARS Practice Note number 31. That practice note dealt with the deductibility of interest on borrowed money. It's essentially where somebody borrows money in order to earn interest income. SARS doesn't like to accept the fact that that may be the carrying on of a trade, and so they published Practice Note 31, and it was published a long time ago, before Section 24J had been accommodated to provide for the deduction of the taxation and the deduction of interest. So it refers to Section 11A rather than Section 24J2, and so on. But the SARS practice was to allow expenditure actually incurred to the extent that interest has been received. Sorry, I should have switched off my cell phone. And SARS has honored that practice in the past, even though they say it's not in accordance with the law. And it was fairly recently announced that practice note was going to be withdrawn, and they called for comment by various interested parties, or by anybody, in fact. And that's where the matter stood. And the intention was to withdraw it with effect from the 1st of March 2003, which is tomorrow. So hence the timing of this podcast. But we learned in the budget speech that that's now been postponed until 1st of March 2024. Have I got that date right, Peter?
Yeah.
So, in a sense, I think it may be much ado about nothing, in the sense that there were problems with that practice note in the first place. And the one problem is that it refers to section 11A rather than section 24J. 11A had a capital versus non-capital requirement, whereas 24J doesn't. But you could apply it mutatis mutandis. But the more serious problem was that the way that the practice note 31 was characterized was that if you borrowed money to earn interest income, you were only carrying on a trade if you were a money lender. Now, I think that is just simply 100% wrong. If you look at the solar glass case, the court was unanimous that the interest expenditure, if I remember correctly, that the expenditure was an expenditure actually incurred, and it was disallowed under section 23G. That's where the majority and the minority judges parted company. But it was accepted that it was of a revenue nature, and that the taxpayer was trading, apart from the unique facts of that case. That, in my opinion, the relevance of the test of whether a taxpayer is a money lender is where a person advances money as a loan, and then the loan goes bad. And whether the capital loss, capital in inverted commas, loss of the principal amount lent can be deducted. And the court said it can only be deducted if the taxpayer is a money lender. That's a different thing. That's part of the capital revenue test. Because in the hands of a money lender, money is its trading stock, or it's circulating capital. I don't think that test applies. If I borrow money and I purchase an asset with it and I rent it out and I'm earning rental income, that's a trading activity, and the interest should be deductible. Anyway, to some extent, the wind has been taken out of our sails, because the whole issue has simply been parked for another year. So the existing practice note will remain in force from now until the end of the tax year, starting tomorrow, and we'll then see what they propose in its place. It seems likely to me that some other practice note or some other measure will be passed. And it won't just simply be a scrapping of the practice note. I don't know, do you have a thought on that, Peter?
Yeah, it's interesting because it's been around since October 1994, as you said, and then in November, apropos nothing, the Treasury released the statement that it was looking to withdraw it, as you said, from March, the beginning of March this year, tomorrow. And they asked for submissions, and they said that the reason they were withdrawing it is because of abuses of the practice note and abuses of circumstances allowed by the practice note. And they didn't give examples, and you sort of struggle to see what those examples might be, how this practice note is abused, because all it is, as you said, is a concession.
Yeah.
Maybe it's a flawed concession, but a concession nonetheless, where if you, and they sort of distinguish between parties that borrow for the purpose of on-lending at a profit, and then parties or taxpayers that just have surplus capital, surplus funds, and park those off and earn interest on them. And it said, certainly in the latter case, you may not be carrying on a trade, and in that case, in those circumstances, they'll grant a deduction, Trevor, as you said, up to the amount of interest received. So you struggle to kind of see what the abuse is, and especially if the abuse is not articulated. My sense is always, if there is abuse, rather deal with the abuse than throw the baby out of the bathwater.
Yeah.
Because the obvious point, we made submissions on this, Trevor, and the obvious point is, if you're a lender to a company and that company takes your money and and deposits it and earns interest. If that company doesn't get a deduction, there's double tax, economically double tax, because that entity now is earning interest, is not getting a deduction, and you earning interest and you paying tax on that. So there's an obvious abuse, if you like, or double tax arising in circumstances where the practice note doesn't apply. So to me, it's more a case of, it's abusive not to have it, if I can put it that way.
Yeah, in other words, abuse can work both ways.
Yeah, I think so. I think so. So, as you said, I think they admitted that there were a lot of submissions made, and I think that's good, and I think that's quite healthy, Trevor. If you go to the mark and you say, we think there's abuse, and what do you think, and let us know, and they give you a couple of months. I think it was a month to respond, long enough anyway. People bashing their submissions, and then National Treasury says, wow, we had a lot of submissions, we're reading them. In the meantime, we're going to kick for touch and withdraw the practice note in a year's time. And I agree with your sentiment, Trevor. I think it's going to be, my guess is that they will either not withdraw it, or they will just amend it and deal with some of the issues that you mentioned, because it is a bit flawed, it is a bit dated, it needs to be fixed up a bit.
Yeah, I agree with that. And then the one thing I didn't mention was there is the case of Tiger Oats, where a holding company lends money to its subsidiaries, either at a low interest rate or interest free, but it's very involved in the management of those subsidiaries. This was a case concerned with regional establishment levies, but the court held that that was trading. So, one mustn't necessarily just back down and accept the practice note. There's sometimes a case to be argued.
100%. I was just going to say that. I'd forgotten, so I wasn't going to say it, but that's what I wanted to say is, what I've been telling clients is, look and see whether you are carrying on a trade, because it's a wide definition. It's a defined term in the Act. And then, as you say, this case law that it's very wide. A single act can constitute a trade. And certainly in cases where, you're borrowing for the purpose of on lending and making a profit, it feels like there's a trade happening there. It's only sort of in circumstances which are, they happen, but where you sort of end up with surplus capital just lying around and you sort of put it on deposit, and it's very, very passive, that maybe there's no trade. But where we see this problem is clients with a multitude of entities all sort of facing each other, and they're complicated sort of restructuring or arrangements often, and sort of one company lends to another, lends to another, lends to another. So in those cases, I think there is an argument to be made that each of those entities does carry on a trade, and that's at least something worth consideration, given the wide concept of trade, both in statute and in case law. So if, goodness forbid, the practice note does go away, I think there'll just be a lot more case on what is a trade. And I suppose the other thing is, people say, well, the practice note, is it binding? No, it's not binding. It's not binding. It's not a binding general ruling. And they're trying to get rid of practice notes, so they're withdrawing some, and others are still sort of lurking around. But currently you just get interpretation notes. You don't get practice notes. It's kind of like an outdated concept. And then some interpretation notes do have the status of a binding general ruling. This doesn't. So, but it is a practice generally prevailing, I think. So what does that matter? It means that SARS effectively can't go back and issue additional assessments if you rely on a practice generally prevailing. So effectively, if they withdraw the practice note, then it's withdrawn only with proactive effect and not with retrospective effect. People don't have to worry about what about the last 10 years, So I think that's probably useful to know as well.
And that's where electronic filing is quite useful, because you submit your return within 10 minutes, you get an electronic assessment. And then if you've relied on the practice note in that, then SARS can't change it.
Yeah, that is true.
Yeah. Anyway, we'll continue to watch this space and see what happens in a year's time.
Yeah, absolutely. Absolutely.
Now for
no
the
reason
main
to
topic.
panic.
Now for the main topic.
Right. The coronation case.
Peter's going to enlighten us about the coronation case, which has certainly got people talking. And I've got a few questions and possibly answers to make, but let's hear what you have to say, Peter.
Maybe just to start with, just, a bit of a summary of our CFC rules. So if a South African resident holds directly or indirectly more than 50% of the shares in a foreign company, the foreign company is a controlled foreign company, CFC. What does that mean? It means that you do a tax calc for the CFC as if it were a South African tax resident, and you come up with its taxable income, and then you allocate an amount equal to that taxable income. And I'm going to come back to that because I think, Trevor, that might be one of your questions. Amount equal to that taxable income back to the South African shareholder, and it's taxable in their hands in terms of Section 9D. There is an exemption, there are actually a few exemptions, but the main exemption from that allocation is in respect of income which is attributable to a foreign business establishment of the CFC. If there's income that's attributable to a foreign business establishment, then it's not allocated back to the South African resident shareholder. So the question is, what is a foreign business establishment? And this became relevant in the context of the Coronation case, because in the Coronation case, CIMSA, CIMSA, acronym for the South African holding entity, indirectly holds 100% of CGFM, which is a fund manager based in Ireland. So, and the question was whether CGFM's net income effectively is allocated back to CIMSA in South Africa under Section 9D. So what is a foreign business establishment? And that basically refers to or requires a fixed place of business of the CFC, where that place of business is, one, suitably equipped with employees who conduct the primary operations of the business. Two, is suitably equipped for conducting the primary operations of the business. And three, has suitable facilities for conducting the primary operations of the business. And then lastly, it mustn't be set up for the purpose of avoiding South African tax. And that wasn't an issue, so I'm not going to deal with that. So my approach to this, Trevor, has always been that this is a factual test. So the first question you look at is determine, as a question of fact, what is the business of the CFC? What does it do? What business does it carry out? Just examine the facts there. And then again, you say, what are the primary operations of that business? So you work out what the business is, then you work out what the primary operations of the business are. So you ignore like ancillary bits of the business or administrative bits of the business. You say, what's the guts of that business? What are the primary operations? And then you look at whether the fixed place of business is suitably staffed, suitably equipped, and of suitable facilities for conducting those primary operations. And I'm going to give you an example in respect of staff. So I always thought about the staff requirement as saying, don't think you can set up a CFC in Mauritius and employ a secretary and do all sorts of complicated derivative transactions through that CFC, make loads of money, and say, but hang on, I've got a foreign business establishment exemption because I've got an employee or employees in Mauritius, and they do some stuff. Yeah, that's what this provision is. It says must be suitably staffed with employees who conduct the primary operations. So if you've got a secretary, that's not the primary operations of your derivative business. That's just an ancillary piece to it. And that's what I've always thought this bit was, trying to carve out. And that makes complete sense to me. So on the facts of this case, CGFM, the Irish company, uses an outsourced business model where it basically focuses on being a product provider. And what that means is functions like investment, administration, custodial services are all outsourced to specialists, third parties, in some cases, related parties and others, but they're third-party entities that carry on those bits of the business. So CIMSA's argument, which I completely agree with, is that CGFM exercised oversight and supervision over the conduct of its service provider. So using my test, you say, what is CGFM's business? And you look at the fact that it has subcontracted a portion of its functions. So you say, but what is its business? So its business is basically managing those subcontract relationships, looking after the subcontractor, making sure they perform their functions, etc. The words used were exercising oversight and supervision over the service providers. And that was consistent with the terms of the license issued by the Irish regulators. So, in my view, you look purely at what the company does, what its primary operations are as a factual matter, and then you say, are those primary functions that it actually carries out conducted by people based in Ireland, and it's suitably equipped and it has suitable facilities for those primary functions it actually does. And then SARS basically argued that that's not the case. It said the primary operations of an entity, in this case CGFM, is more of an objective kind of test. You don't look at what it actually ends up doing. You look at, for example, its memorandum of association and other sort of objective factors. And if those state, as they do in this case, that the company is an investment management entity, then they say the minute you subcontract some of those primary parts of your business to another service provider, you're no longer performing them, and the foreign business establishment exemption doesn't apply. So that was their argument, and the court went with SARS's argument in this case. They said, it looked at the memorandum of association of the company, it looked at a couple of other things that sort of objectively pointed to CGFM having a primary business on an objective basis of investment management, and said, but as soon as you start subcontracting that to someone else, you're simply not performing those functions, and so the foreign business establishment doesn't apply. So Trevor, quite a sort of a nuanced sort of, argument, I suppose. But, for me, as I say, I've always thought of it purely as a factual question. Look at what your business is, look at what your primary operations of that business are. And then you just say, well, who actually does the primary operations? Who performs that? And if that's done, in this case, from Ireland, then you are home free. You don't look at it sort of objectively with reference to sort of, maybe your memorandum of association or other objective evidence. It's purely a factual test for me.
Yeah, because they looked at the memorandum of association and also at the terms of the license.
Exactly, yeah.
The Irish people.
And,
my understanding is that part of the reasoning was the court was that you have to have that power yourself, the investment power, in order to be able to outsource it. So you've got the power yourself, and then you grant the use, you exercise that power by giving it to somebody else. Which means that you did have the power in the first place. But that power is not exercised in Ireland, and therefore the foreign business establishment exemption doesn't apply.
Exactly. Exactly. And, as I say, I've always thought, and I think that's why it came as a bit of a shock to the tax fraternity, this judgment, because I think myself and a lot of people in the industry and advisors in the industry have taken the other approach, what I call the factual-based approach, where you just look at the company's business and you look at what it actually does, and you look at what the guts of that business is, the primary operations, if I can use the technical term.
Well, isn't it arguable that that is how you should interpret Section 90 and foreign business establishment, because that's a commercial interpretation. Otherwise, and I remember from one of the cases used the expression, and it always used to amuse my erstwhile students, the Latin maxim of qui facit per alium facit per se. It sounds a bit vulgar, but it's how you pronounce the Latin. If you do something through another party, you're doing it yourself. And how does that tie in with outsourcing? I'm not sure.
I like that, and I also, if you just think about the economics of this, so because the SCA went on, quite a long sort of just analysis of sort of the fact that 9D is an anti-avoidance provision, and there's a lot of anti-avoidance kind of language in the judgment.
Where does that come from?
Yeah, I mean, but if you think about the economics of what we're doing here, so if CGFM subcontracts a whole lot of its functions, then it needs to pay the subcontractor for doing it. People aren't going to do something for nothing. And if it's a related party, then transfer pricing is going to say that you CGFM need to pay an arm's length price to the third party service provider. So what happens when you do that? Effectively, you reduce your net income and you reduce the amount that's not allocated back to South Africa. So the economics of it, there's no anti-avoidance in subcontracting functions to someone else, because you end up paying for them, reducing your profits, and less stays in Ireland and less is not taxed in South Africa. I mean, I don't get how that wasn't sort of dealt with as an anti-avoidance matter. There's no anti-avoidance in subcontracting.
And the judge, with respect, you can just see in the language used, that's the sort of paradigm of the approach to the problem. And
anti-avoidance.
My attitude is the CFC, the controlled foreign company, is not a resident of South Africa, and it's not effectively managed in South Africa. So it's not part of the South African tax base. So how can you talk about it being an erosion of the South African tax base?
Yeah, as a starting point.
And it's underpinned by commercial reality. South African investors are looking for exposure to offshore investments. So there's a commercial investment aspect to the whole thing. And that is achieved by outsourcing it through Ireland in those markets where people have the expertise to make those sort of investments. That's why I think that the interpretation should maybe follow that more practical line.
And just to answer, I would sort of preempt a question I think you asked earlier, Trevor, not in this video, by WhatsApp, is the double tax agreement. What does a double tax agreement say about all of this? Because we've got a double tax agreement with Ireland, and the way that 9D works quite cunningly,
right here.
quite cunningly, as it says, instead of saying the taxable income of CGFM is allocated back to SIMSA in South Africa, in which case you could say, but hang on, that taxable income is taxable only in Ireland, because SIMSA doesn't operate through a permanent establishment in Ireland. So South Africa, you don't have any taxing rights. Instead, it says an amount equal to the taxable income. So a notional amount is calculated and is taxable in the hands of SIMSA. And therefore, the argument is that you're out of the treaty, because the treaty simply doesn't apply. There's simply, as a matter of having domestic law, there's a notional amount determined and allocated to a South African resident, and the treaty doesn't impact on that because it's not the taxable income of the foreign entity. And that was changed way back in 97, I think, that they changed that wording soon after they introduced the rules.
Which I would respond if I were on the bench. Mr. Dachs, do you think I was born yesterday? Or as one judge once actually did say to the late, what was his name? I'll think of his name in a moment. I need his answer. Meneer so-and-so, dink jy ons is 3 Bobbiane wat hier sit? While you were talking, I've just got section 9D in front of me, and subsection 2 says, there shall be included in the income for the year of assessment of any resident other than a resident that is a headquarter company. That's really the solution. Who directly or indirectly holds any participation rights in a controlled foreign company, A, on the last day of the foreign tax year of that controlled foreign company, which ends during the year of assessment, an amount equal to where that foreign company was a controlled foreign company, the proportional amount of the net income of that controlled foreign company. You could say it's an amount equal to, but surely,
I like it, Trevor.
To say it's not, you're not taxing that income. I mean, come on.
And to at least raise that.
Wat hier sit.
Raise that as an alternative as well. That's never been tested in South African tax law, So yeah,
I mean, it's just too cute. So okay, firstly, we're not taxing the Irish company in South Africa. We're taxing the South African holding company, and we're not taxing that income. We're taxing an amount equal to that income. Oh, come on, man! That is the article, and again, Peter, this is your field rather than mine. But Article 7 of the Irish-South African double tax agreements is headed business profits. And it says profits of an enterprise of a contracting state shall be taxable only in that state unless the enterprise carries on business in the other contracting state through a permanent establishment.
Yeah.
Not applicable on these facts. And the phrase enterprise of a contracting state means an enterprise carried on by a resident of a contracting state. And that company, the acronym of which you've got fingertips, that was an Irish company.
Yeah, CTFM.
So I'd be very happy to stand up in front of other 5 or 11 judges and argue that point. But I hasten to add, I won't be doing so. Otherwise, just, I mean, let's talk substance and form. In substance, it is the income of the Irish company. That's where it's.
I like that argument. You can turn substance and form, on its head a little bit there and say, okay, so do you really think you can sidestep the treaty by just saying it's an amount equal to the taxable income of that Irish company, and then that avoids the problem?
And taxing it in another entity.
Tax it in another entity. So, as I say, it's never been determined.
What's interesting here, so I think it's safe to say that the DTA, the double tax agreement, allocates the taxing rights in respect of that profit, or that, in other words, that income to Ireland. So it's the income, not the taxpayer. Anyway, I suppose one would have to test that point. But having read from the section itself, it says, other than a resident that is a headquarter company. So I mean, my understanding is, and this is totally hearsay, I'm not involved in the matter at all, but I hear that was a 2012 year of assessment involved. That's clear from reading the judgment. But I hear that the amount involved is something in the order of R1 billion. And if that's going to apply to 2012, 13, 14, 15, right up to the present, that's massive implications. Solution is to use a headquarter company.
Just the other point I wanted to touch on, Trevor, was understatement penalties, because that now is becoming very interesting. Because now we've had 3, this is, I think, the 3rd judgment, or at least the 2nd, because we talked in our last podcast about the Thistle Trust case. And this has basically said exactly the same. So the court confirmed that if there's an understatement, you need to pay understatement penalties, unless the understatement arises as a consequence of a bona fide inadvertent error. And the court here again, SCA, saying the same thing. And it said there was nothing to suggest that SIMSA, the South African company's tax returns, were not submitted in the bona fide belief that CTFM was eligible for exemption under Section 9D, and that there should have been no allocation made. And I think that's huge. Again, I made the point in our last podcast, because that cuts very much against SARS's interpretation of bona fide inadvertent error, where they kind of say it's finger trouble, you add an extra nought in your tax return. And there was quite a lot of in the judgment around the tax opinion, because there was a tax opinion obtained, wasn't provided because it was to SARS because it was legally privileged. And the SARS counsel tried to get the court to make an adverse inference from the fact that the legally privileged opinion wasn't made public, in the sense it's saying, well, it must have been negative, which I think the court correctly rejected.
Yeah, that's just absolute nonsense. I mean, it's privilege. So there's a reason for privilege. It doesn't mean that you're scared to disclose or anything like that. It just means you don't have to.
Exactly. And so the court didn't fall for that.
If I remember correctly, Judge Nichols actually referred to the Thistle case.
Yes.
We discussed last time.
Yes.
And there's stuff in the Thistle case. I was involved in that case, and there were statements made in court which are not apparent from the judgment. I wonder if Judge Nichols actually spoke to the other judges. I think she must have to be able to compare the two. Anyway, it was 100%. Nice. It was nice to see that the one redeeming feature of Thistle was also a redeeming feature of Coronation.
True, and I think that's a big point, because that's very much a general application in the stuff that we do for clients all day, every day. So, and then just the last point, Trevor, I think because we probably overstepped our time and our listeners' patience, but the last point is that with the budget, the Treasury said they're going to amend the law, they're going to amend the foreign business establishment exemption in the light of the Coronation case. Didn't say that, but that's effectively what they're going to do. to refine the concept of foreign business establishment to say that, if you have an outsourced model, effectively, you can't qualify for the foreign business establishment exemption, which is actually quite interesting. So, won the case in the SEA, but still going to amend the law. So, we need to kind of watch that space as well.
Can I ask? I don't have the experience to know this, but I would imagine that if Coronation were using an outsourced model, there must be a whole host of other companies that were doing the same thing.
Yeah, and so I think that's the concern in the market.
The commercial impact of that decision is enormous.
Enormous, actually, because as you say, it's not retrospective, because the SCA is just telling us what the law has always been. So effectively, it has a retrospective effect there, which is the scary part.
Yeah.
So this is quite dramatic news.
Absolutely. So we'll see what happens.
Yeah,
No doubt they've applied for leave to appeal to the Constitutional Court, and that's placing it in the lap of the gods. Who knows what's
That's a beautiful way to end off. Thanks,
Peter,
Trevor. Nice chatting.
That 3/4 of an hour or half an hour vanished very quickly.
Very nice chatting,
but
Trevor.
the effect of Coronation will linger on.
That's true.
Sadly. Anyway, one wonders when the taxpayer is going to win a case in the Supreme Court of Appeal.
Yeah, it is. It's definitely over time now.
But I do have a vested interest in posing that question. I'll be there a week on Monday.
Okay, brilliant. Good luck for that.
Oh, okay.
Thanks, Trevor.
Nothing of earth-shattering importance compared to Coronation. But that really must be a massive blow to the company, I must say. Anyway, thanks to our listeners. We have an increasing number of people who listen to these podcasts, and thank you for the positive feedback. I welcome feedback of all types, whether positive or negative. We can only improve. Peter, thank you very much, and thanks for our listeners. See you soon.